Swayam Prabha. Digital India. Educated India.
Hello everyone, this is Dr. Shabnam, Associate Professor from the Faculty of Law, University of Delhi. This is my lecture number 12 and I will be talking about the forest laws in India. I have taken this topic as a lecture number 12 for the reason that this was the first law which was brought in India with respect to environment. We did not have any other law even in our ancient societies, but the forest and the respect for the forests persisted even in the ancient societies. So these laws in India, when they are framed, these hold importance as the first environmental laws framed either in an ancient manner or during the British rule or during the current rule which are to be implemented for protection of environment. Forests have been defined in different ways in accordance to the kinds that exist in the world. These definitions are related to human interactions and approach to kinds of forest in different regions. As defined under the Convention on Biological Diversity 1992, a forest area is a land area of more than 0.5 hectares with tree canopy cover of more than 10%, which is not primarily under agriculture or other specific non-forest land use. In the case of young forests or regions where tree growth is climatically suppressed, the trees should be capable of reaching a height of 5 meters in situ and of meeting the canopy cover requirements. The forests are a large area of land dominated by trees. The forests are defined by the Food and Agricultural Organization as all lands bearing vegetative association demarcated by any trees of any size, exploited or not, capable of producing wood or other food products. According to the data of the Food and Agricultural Organization, or the FAO as it is in brief referred to, forests cover 4 billion hectares or approximately 30% of the world's land area in the year 2006. They are pivotal to preserve the ecosystems. They provide humans with various essential commodities such as air to breathe, wood, vegetables, etc., which are a must for survival. The forests are a blessings for human beings from the nature, and therefore it becomes our duty to preserve and protect these forests. They constitute a large part of the ecosystem and a part of the Earth's biosphere. Preservation of forests. The United Nations Strategic Plan for Forests 2017 to 2030 provides a global framework for actions at all levels to sustainably manage all types of forests and trees outside forests and halt deforestation and forest degradation. The strategic plan has 6 goals to achieve by 2030 as enumerated thereunder. The sustainable forest management provides the key to recovering forest cover losses and afforestation and reforestation for prevention of further degradation. The livelihoods of forest dwellers to get improved by providing forest-based benefits, the world to have more areas of protected forests and manage them sustainably, to have partnerships and cooperations for providing finances and scientific technologies for sustainable forest management, providing frameworks for governance for sustainable forest management with the help of United Nations Forest Instrument, thereby enhancing the contribution of forests to the 2030 agenda. To enhance cooperation, coordination, coherence and synergies on forest-related issues at all levels, including within the UN system and across collaborative partnerships on forests, member organizations, as well as across sectors and relevant stakeholders. The history of the forest laws in India. We have a very interesting history because the forest and the trees were worshipped in our ancient societies, and they were not asked to be overexploited, for they represented our religious sentiments during those times. So, in ancient India, Yajna Valkya Smriti, an ancient text, called for punishment for cutting down trees. Then it was the British period which came in and which brought in the formal laws in our country. They, for the purpose of exploitation and taking away the riches or the rich biodiversity reserves in our country, they drafted specific laws in relation to forests. It was in 1850 that the first Inspector General of Forests was appointed, and 1860 first Forest Department was established. In 1865, the Forest Act was drafted and made, and in 1878, the Forest Act took away the community rights of forests from the local people, from the community people, and from the tribals. It was in 1894 that the first forest policy with focus on agriculture than forests was drafted and brought into force. It was finally the Act of 1927 which repealed all the previous laws and took away more rights of the people living in these areas. It was in 1952 that the first forest policy of independent India, taking rights from the princely states and zamindars, was brought into force. This was after India gained independence, and India drafted its own policy to deal with the forest areas. Then in 1976, there was the National Commission on Agriculture for Production of Industrial Wood. In 1976, there was a 42nd Amendment which was made, where forest laws went from state list to the concurrent list. In 1980, the Forest Conservation Act was brought into force and was amended in 1988. It was in the year 2006 that the Forest Dwellers Act came out, which gave more rights to the forest dwellers than what was previously done during the previous years. And in 2022, forest rules have been brought and which have come into force. So, the current position of forests in India is the recorded forest area in India is about 76.5 million hectares, which is only 23% of the total land mass. During the last 2 decades, India has witnessed annual depletion of forest cover at the rate of 235 kilometers. According to the government data, 14,000 square kilometers of forests were cleared to accommodate 23,716 industrial projects across India for the last 30 years. These figures are certainly not good and are not in the interest of our nation. Thus, it becomes pivotal to improve the situation and to ensure the protection of forests. Protection of forests comes within the ambit of the directive principles of the state policy in the Constitution of India, where it seeks the duty of the citizen and the duty of the state to work towards the protection of natural resources and specifically the forests. Section 48A of the Constitution deals with that the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of our country. The Constitution also entrusts the duty of protection of forests on citizens as a fundamental duty. And under Article 51A, subclause G of the Constitution, in 1950 embodied that it is the fundamental duty of every citizen to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures. This law is placed in the concurrent list. Until before 1976, forests and wildlife were the state subjects in the Indian Constitution. The forest departments are regulated forests in accordance with the Forest Act of 1927. Recognizing the significance of forests and wildlife, the 42nd Amendment to the Constitution deleted both from the state list and placed them in the concurrent list, bringing them under the purview of both the central and the state governments. Now, both the centre and the states may legislate on issues pertaining to forests and protection of wildlife. The reasons for drafting. Now, I will again take up the history of the forest law since they started during British India. in 1856 that Lord Dalhousie emphasized the need for a definite forest policy. Railways was first introduced in India in the year 1853 from Bombay to Thane. Increasing difficulty of obtaining adequate supplies of timber needed for the great extension of railway lines then being undertaken was one of the main reasons for this cognizance. Another reason was the Indian teak, which was suitable for shipbuilding, saved England during the war with Napoleon. In 1865, the Indian Forest Act of 1865 extended the British colonial claims over forests in India. In the year 1878, the Forest Act was introduced and it truncated the centuries-old traditional use by the communities of their forests and secured the colonial government's control over the forestry. The provision of this act established a virtual state monopoly over the forests in a legal sense on one hand and attempted to establish on the other the customary use of forests by the villagers was not a right but a privilege that could be withdrawn at will by the government. The Indian Forest Act of 1865, it was a significant piece of legislation during the British colonial period. The historical context and implications are that Lord Dalhousie, the then Governor General of India, recognized the need for a definite forest policy. It introduced railways in India, highlighted the difficulty of obtaining adequate timber supplies for railway expansion, the Indian teak, which was crucial. The Indian Forest Act extended British colonial claims over forests in India. It empowered the British to declare any land covered with trees as a government forest and establish rules for its management. The Act aimed to address the timber scarcity issue by asserting control over the forests. The impact on traditional use. The Forest Act truncated centuries-old traditional forests used by the local communities. It established a virtual state monopoly over the forests, emphasizing that villagers' customary use was a privilege rather than a right over these people. The forest laws in India. The directive principles of the state policy and the fundamental duties enshrine these specific provisions. As I have previously stated, this was established for the first time in India by the British in 1865 and it was amended and Indian Forest Act 1878 was passed. This classified the forests into reserve forests, protected forests and village forests. Under this act, the government was empowered to exercise control over the forests. The Indian Forest Act of 1878, it was exploitation under this act was extensive by the British as they gained control over the various lands, forest cover of the country with colonial interests at heart. They achieved this by exploiting local resources as the local people as well as the forest dwellers who conducted all their daily activities and practices such as agriculture, shifting agriculture, grazing cattle, etc. These for the purpose of exploitation were considered harmful to give more control to forest officers and indirectly to the British rule in India. The commercial interest in timber and other produce led to the framing of this law to deprive the people and gain economic benefits for the same. The Indian Forest Act 1878 and the case examples were in the Kumaon and the Garhwal hills of the present day Uttar Pradesh and Uttarakhand, the softwood reserves of Deodar and Cheer pine trees had the economic potential to fulfill the demands of the expanding railway network and the military endeavors. Exploitation of locals by depriving them of ancestral rights for revenue generation led to the encroachment on indigenous lands of teak forests in the Dang district and the Deodar forests in the upper Yamuna valley. To maintain control over the forests and suppress tribal rights, the British established indigenous ruling class as an intermediary between themselves and the tribal communities. The freedom movement gained momentum because of these rights being taken away, and the revolt took place in Chota Nagpur in 1893, Bastar in 1910, Godam Rampa in 1879 to 1880 and 1922 to 23, Midnapur in 1920 and Adilabad in 1940. The Indian Forest Act was then passed in 1927. It was passed with the objective of improving forest laws in India. This act repealed all the previous laws pertaining to forests. It emphasized upon consolidating the forest laws pertaining to forests and ensure regulation and transit of the forest produce. It consolidated the law relating to forests, the transit and the duty leviable on the timber and other forest produce. It is expedient to consolidate the law relating to forests because of the following reasons. The Indian Forest Act 1927 and its applicability. It is a consolidated law which related to transit of forest produce and the duty to be levied on the timber and other forest produce. This act came to be known as the Indian Forest Act of 1927. It extended to the whole of British India or the rule of British India, except the territories which immediately before 1st November 1956 were comprised in the Part B states. It applied to the territories immediately before 1st November 1956 and comprised of the states of Bihar, Bombay, Coorg, Delhi, Madhya Pradesh, Orissa, Punjab, Uttar Pradesh and West Bengal. But the government of any state may by notification in the official gazette bring this act into force in the whole or any specified part of that state to which the act extends where it is not in force. The reserved forests. The provisions related to the procedure which was established for exploiting the local people and their rights by providing compensation and declaring the lands as reserved forests, thereby relinquishing their rights in their own lands. This was basically a deliberate attempt of the British government to firstly ask for the claims which were made by the local people involving their rights on their land, to settle for a monetary compensation and to give up their rights over their personal lands which they had made use of in the past centuries for their daily lives. This was the power to reserve forests, notification by the state government, bar of accrual of forest rights, proclamation by forest settlement officer. Officers were appointed to settle claims of the local people or of the indigenous people who claimed rights over their own lands. Inquiry by the forest settlement officer, powers of the officer, extinction of rights, treatment of claims relating to practice of shifting cultivation, treatment of claims relating to practice of shifting cultivation, power to acquire land over which right is claimed, orders on claims to rights of pasture or the forest produce, records made by forest settlement officers, records where they admitted the claims, exercise of the rights admitted, commutation of rights, appeals from the orders passed under section 12, appeals under section 17, pleaders to be appointed, notifications declaring forests as reserved areas, publication of translation of such notification in neighborhood of the forests, the power to revise arrangements made under section 15. No rights after that would be acquired over the forest lands which were declared to be reserved forests except those rights which are not to be alienated without sanction. Then there was the power to stop ways and water courses in the reserved forests. Acts prohibited in such forests were not to allow entry and exit of those people who owned those lands after once compensation claims have been made. Then the power to declare forests are no longer reserved. Then came the category of the village forests and the protected forests. Provisions related to village and protected forests were covered under sections 28 to 34. Under section 28, the provision of declaration of lands as formation of village forests. This act brought the law to allow certain lands to be the village forest for community, but the rights remained with the government to change their status any time. The law also went to establish the procedure for declaration of wastelands or no ownership lands to be the property of the government. Then came the protected forests. The protected forests under chapter 4 provided the power to issue notification reserving trees, publication of translation of such notifications in the neighborhoods, power to make rules with respect to these protected forests, penalties for acts in contravention of the notification issued under section 30 or rules made under section 32, nothing in this chapter to prohibit the acts done in certain cases. Then comes protection of forests, control over forests and lands not being the property of the government. there was protection of forests for specific and special purposes. Where these forests provided a specific reason for their protection, they were asked to be protected. The power to assume the management of these forests, management of the forest, the entry, the exit, the right to make use of the produce, not to fell down trees or to fell down only those trees which are no longer in use, are the decisions which will be assumed to be made with respect to the management of forests. Exploitation of forests in certain cases, and there were certain then requests made by certain private people for the protection of the forests at their requests. Then comes the duty and control on timber and other forest produce, that there were taxes to be paid and duty to be levied on any forest produce which is likely to be taken or purchased from the forest lands which are so declared as such. The power to impose duty on timber and forest, and the limit not to apply to purchase money or royalty only. It could be more, it could be less, depending on the case to case basis. The collection of drift and stranded timber. Under section 45, certain kinds of timber were deemed to be the property of the government until title thereto was proved by the person or the collector, and may be collected accordingly according to the procedure. The notice to claimants of drift timber. Drift timber means the timber which has been left aside and where rights could not be claimed because of the flow of timber, or they are left unattended and they are taken into custody by the government, where the person has to prove special ownership over that timber to claim his rights. Procedure on claims preferred on such timber. Disposal of unclaimed timber, and government and its officers not liable for damage to such timber. Payments to be made by the claimant before timber is delivered to him, payment in the form of taxes, payment in the form of duty which might be levied, and then the power to make rules and prescribe penalties. What are the penalties and the procedure which has to be adopted? Seizure of property is liable to be confiscated. Power to release property seized under section 52. The procedure which is followed thereafter. The forest produce when liable to confiscation, that is when they are left unattended, drift timber when they are flowing down the river and the claims are not there, are likely to be confiscated. Disposal on conclusion of trial for forest offence of produce in respect to which it was committed. Procedure when the offender is not known and cannot be found. Procedure when it is a perishable property seized under section 52. Appeal lies under section 55, section 56 and section 57 in case the decisions have been taken. Then the property when to vest in the government is after no claims have been made or claims have been denied of the persons who claim to be the owner. Saving of power to release property seized. Punishment for wrongful seizure. Penalties for countering or defacing marks on trees and timber or altering boundary marks. Power to arrest without warrant. Power to release on a bond a person who may be arrested. The power to prevent commission of an offence, and power to try offences summarily, which means in a quick manner or in a short summary manner, where they are not compoundable or they are offences which are not of grave in nature. Power to compound offences and presumption that forest produce then belongs to the government. They were all British policies by which it went on to gain more control of the government over the forests and the produce which might be coming along. Then comes the rights of the cattle trespass, the forest officers and the subsidiary rules. The Cattle Trespass Act 1871 was to apply. The power to alter fines fixed under the Act. The forest officers, the state government may invest forest officers with certain powers, and in 1927 they were again asked to pay the claims made by the government over their lands. The forest officers were deemed to be public servants and indemnity for acts which were done in good faith. Forest officers were not to conduct trade, and the subsidiary rules went for making additional power to make rules, penalty for breach of rules, and rules when they are to come into force. So, it went on to display an absolute power in the then government to dispose of, to take into custody any forest produced timber or anything which is of a commercial value when it relates to a produce which is coming out of those forests, and then laying claims over the lands which are covered in forest areas. The persons who are bound to assist forest officers and police officers, they were bound to be helping hands and they are not to be punished in any kind of procedure. The management of the forest, it will be the joint property of the government and other persons. Then there is failure to perform the service for which a share in produce of the government forest is enjoyed. There is recovery of the money which might be due to the government. There is lien on the forest produce for such money. The land required under these acts are deemed to be needed for a public purpose under the Land Acquisition Act 1894, and the recovery of penalties due are made under bonds. Saving of rights of the central government. The forest policy. After the forest law has been passed, which still till date follow certain laws which were made during the British at that time, although they were arbitrary laws and policies, still they defined the areas as to what are forests and what are the kinds of forests which existed in India, to which the rules and policies amendments were made and new policies came out from time to time. So, the first policy which was enacted was in the year 1952, immediately after the India gained independence. In 1988, the policy was revised by the Parliament to revise the previous enacted policy of 1952. The objective was to ensure that the management of forests is undertaken in a sustainable manner and the local tribal communities are empowered and involved in their protection and development. A direct outcomes of the policy was establishment of a joint forest management system. This policy aimed at maintaining environmental sustainability and stability, recovering ecological balance, protecting natural heritage with flora and fauna, preventing soil erosion, floods, droughts, as well as increasing forest cover through afforestation programs. The forest policy also sought to promote efficient utilization of forest resources for meeting basic human needs such as fuel, wood, fodder and small timber, while ensuring that these activities do not lead to deforestation or degradation. It emphasized the need for conservation of biological diversity by protecting endangered species and preserving genetic diversity. It further suggested measures for improving productivity through scientific management practices such as silviculture and agroforestry. The National Forest Policy 1952, the Government of India in the Department of Revenue and Agriculture in broad outlines gave out a general policy to be followed with the management of the state forests in the country. The interval that had since lapsed, development of far-reaching importance had taken place in the economic and political fields. India had gained independence, as I stated previously. The part played by forests in maintaining the physical conditions of the country had come to be better understood. The country had passed through the 2 world wars, disclosed unsuspected dependence of defense in the forests, reconstruction schemes such as the river valley projects, development of industries and communications leaned heavily on the produce of forests. While the fundamental concepts underlying the existing forest policy still hold good, the Government of India considered that the need has now arisen for a reorientation of the forest policy in the light of changes which have taken place since it was enunciated. The needs of the forest policy of 1952, the need for evolving a system which was balanced and complementary land use, under which type of land is allocated to that form of use under which it would produce most and deteriorate least, need for checking for denudation in mountainous regions in which depends on the perennial water supply of the river systems whose basins constitute the fertile core of the country, erosion which progress space along the treeless banks of the great rivers leading to ravine formations, stretches of undulating wastelands depriving the adjoining fields of their fertility. the invasion of the sea sands on coastal tracts and shifting of sand dunes, more particularly in the Rajputana desert. The need for establishing tree lands wherever possible for the amelioration of the people and climatic conditions promoting the general well-being of the people, the need for ensuring progressively increasing supplies of grazing, small wood for agricultural implements, particularly of firewood to release the cattle during dung for manure to step up food production, need for sustained supply of timber and other produce required for defense, communications and the industry, and the need for realization of the maximum annual revenue in perpetuity consistent with the fulfillment of the needs enumerated above. The necessity and classification of forests. It is the functional classification of these forests. The forests of India with the state or privately owned may be conveniently classified into the protection forests, which are preserved or created for physical and climatic considerations, national forests, which are managed to meet the needs of the defense, communications and other purpose of public importance, the village forests, which have been maintained to provide firewood, to release cow dung for manure, to yield small timber for agricultural implements and produce for local requirements to provide grazing for the cattle. The tree lands, which outside the scope of the forest management are essential for the amelioration of the physical conditions of the country. This collaboration is illustrative and it is not mutually exclusive. The forest performs more than one function where it is managed to achieve the highest efficiency in respect of the chief functions, and the classification has no bearing on the classification of the forest distinguished under the Indian Forest Act, which was based on degree of control exercisable by them. The necessity of the classification. The classification is necessary to focus attention on the kind and object of management necessary in each case. Every sizable forest, where whatever its composition, location, category, because of protective and productive purpose and the utility which may be local, regional, national significance, it must be realized that the country as a whole must stake claim in the conservation of all forests, irrespective of their functions and ownerships, and all of them should be administered from the point of view of the national well-being. Balancing the rights and the protective measures. There are claims of the neighboring communities, that is, village communities in the neighborhood would make greater use of its products for the satisfaction of their domestic and agricultural needs. No event is to be permitted at the cost of national interests. Accident of a village being situated close to the forest does not prejudice the right of the country to receive the whole benefit of a national asset. Scientific consideration for forests inevitably involves regulation of rights and restrictions on the privilege of the user. The relinquishment of forest lands for agricultural purposes, the indiscriminate extension of agriculture with the destruction of forests not only deprives the local population of fuel and timber, but also strips the land of its natural defenses against dust storms, hot winds and erosion. The old policy which envisaged the relinquishment subject to certain safeguards, honoured only in their breach, every valuable forest and permanent cultivation has resulted in the general deterioration of physical conditions to the detriment of national interests. Then comes the land use. The correct solution of land problem is to involve a balanced and a complementary land use, where each type of land is allotted to a form of use under which what produces most and deteriorates least. A detailed survey of lands to their proper utilization is highly desirable. The protection forest denotes forests found or required on hill slopes, river banks, seashores or other erodible localities. In such sites, the forest covers is dictated purely protective physical considerations. The role is to save the soil from being washed away, maintain the catchment areas, prevention of floods and maintenance of the stream of flow, and it cannot be overemphasized. So these measures they should provide an immediate and speedy program for the reconditioning of these regions wherever they are required for protective and preserving the forests. The reconditioning of the hills and the dales, the progressive denudation of hillsides with serious repercussions on the fertility of the land, and the growing erosion along the bases of the river Yamuna, the Chambal, the Mahi, the Narmada, the Kosi and Damodar are notorious examples which constitute the major considerations demanding immediate action. The immobilization of the desert of Rajputana, attention has to be drawn to our desert region, where fixation of shifting sand dunes, the strong winds that develop in the region during the summer which arrive from the sea, and the run of Kutch whipping the desert into dust storms, the fury which is felt out in the northwestern India, desert area spreads through the ages because the westering of Indus and mothering of the Satluj meeting an obstruction of sorts not only on its eastern confines in the Aravalis. The immobilization of the desert and protection of the remaining fertile belts constitutes one of the planks of the national forest policy. The kinds of forests and scope of increase of tree lands. National forests constitute the basis of India's strength and wealth, and they comprise valuable timber which bears regions the produce which is indispensable for defense, communication and other vital industries. The village forests, they provide fuel forests. They are popularly termed as fuel forests, and they serve needs of the surrounding villages with respect to small timber, housing and agricultural implements and other small uses, including cattle grazing. The supply of these requirements are at non-competitive rates, and they are used by the villagers themselves, and it is not for the trading purposes. These meet the needs of the local population. Removal of the produce in excess to its annual growth should not be permitted, where they should be guarded against and also guarded against hazardous activities. The tree lands. The tree lands are not a part of the regular forests in a country like India, where their increase, management and development are vital to the needs of the people. They cannot well be left out of any considered policy. The land transformation program of the government envisages the planting of 30 crore of trees in 10 years, but this is far from the 2000 crore of trees which will be necessary to restore the hydrological nutritional balance of the country. The scope for increasing tree lands. It is a vast scope for increase in tree lands for the purpose which have been defined here, and to lend a helping hand by converting these lands at their disposal into tree lands. The new forest policy envisaged a concerted and a supreme effort on the part of various governments and other agencies to promote planned afforestation, a systematic program for extending existing tree lands, and the new one should be framed by the government. This was to awaken the interest of the authorities for the protectionist policies for these tree lands, to draw plans for the same, to establish nurseries and seed stores to supply saplings, plants and seeds, supervising the planting and render technical assistance wherever it is necessary, to arouse the consciousness of the people by celebrating one Mahotsav. Utilization of forest areas for different purposes. The proportion of forest areas as they are, proportion is to be kept in mind under forests are different in different regions. They shall maintain 1/3 of its land under forests. An insurance against denudation, a much larger percentage of land above 60% should be kept for forests for protective functions in the Himalayas, the Deccan region and other mountainous tracts. Then the wildlife. The National Forest Policy emphasizes the need of protection of the animal kingdom and the rare species like the lion, the horned rhinoceros and which is fast disappearing. The other species of animals which without the creation of forests would not be in their natural habitats. The purpose of grazing. The state forest calls for a definite clear policy. Formulation of a grazing policy was based on the following principle. Continuous grazing on the same land by large herds would be destructive. Cheap forest grazing has a demoralizing effect. The grazing should not be looked upon as a primary source of revenue. It must be allowed in regeneration areas and young plantations, and grazing incidents should be kept at the minimum level in protected forests. Sheep and goats. Experience gained in India elsewhere points to the imposition of restrictions on sheep grazing in the forests and exclusion of goats therefrom. The damage of young plants caused by browsing of these animals is often irreparable, and their admission into the forest is incompatible. Then shifting cultivation. Shifting cultivation in certain areas must be guarded to wean the bourgeonals who eke out of a precarious shifting from axe cultivation, moving from area to area away from the age-old and wasteful practices. This needs to be explored. Sustained yields. Forest resources should be conserved till perpetuity. Forest policy requires scrupulous regard for sustained yield in the management of all classes of forests. The fluctuations in the annual turnout of forests upsets the state budgets, industries and other national enterprises. All working plans therefore should aim at confining them within the narrow limits. In the forest administration, which depends directly on the adequacy of the forest laws, the training and the caliber of these forest services, the forest legislation. Absence of a legislation or a half-hearted legislation is detrimental for certain areas which relate to the forests. State without a proper Forest Act should enact a legislation at an early date in the lines of the Indian Forest Act and validate the act for their territories. Forest education should be provided to not only the people but also the forest rangers and forest officers at research institutes and colleges. The training of the field staff, the services which are there, the idea that since forests grow by themselves, they need no technical management is based on ignorance. Inadequacy of technical personnel and weakening of the standards called upon to manage forests would not be followed, but would only be followed by a loss of revenue, which by a general degradation of the forest resulting in reduced forest produce. Forest research should be carried out in various areas, and then there should be the liaison with the industry. It is a considerable scope for improvement in securing the utilization of results of research on forest products by commercial and industrial interests, for ensuring closer interactions between the Forest Research Institute and the interests utilizing timber and forest produce. Liaison and publicity arrangement of the institutes needs to be strengthened. The miscellaneous provisions talk about the popular goodwill of cooperation and forest workers. The forest budgets, where a steady flow of funds is indispensable for a sustained forest operation, such as replacement of what is removed annually, improving remaining crops, development of communications and likewise and protective measures. They are based on phase schemes which cannot be set aside lightly. The forest budget cuts made from year to year meet the exigencies of the state finances can only be made at the expense of continuity in forest management. Creation of a sinking fund by investing a portion in government securities. Immediate profit motive should be rigidly ruled out, for this urge may endanger the supply of large and special timber for defense and industry and other uses. Adoption of rotation to produce large size timber is of great importance to the general economy of the country, and that rotation which yields the maximum rate of interest in forest investments. Policy and enunciation of the general principles. Discretion of the state government to regulate the details of the forest administration in their respective territories is unfettered. The general principles of the forest policy should paramount be of national interest, be observed by them in framing policies and legislations for forest resources. Objects and reasons. It was published in the Gazette of India 1926, which was considered repeal in relation to Assam. The scheme of the law, the scope of the Act, the construction of the Act, the jurisdiction of the civil courts, procedure for trial of forest offences. The Forest Conservation Act of 1980. Now, this was the main act. A policy only was framed in 1952. Till 1980, they continued to follow the Forest Act of 1927 with its various provisions which applied to all forest lands in India. The Forest Conservation Act 1980 was passed to ensure the conservation of forests. It required it was to be made it compulsory to obtain the prior approval of the central government for diversion of forest lands for non-forest purposes. It was mandatory to have a clearance from the central government for re-reservation of reserved forests and for use of forest land for non-forest purposes. This was under section 22 of the Forest Conservation Act of 1980, that there were restrictions on de-reservation of forests or use of forest land for non-forest purposes. So, this made the prior approval from the central government mandatory. If you reserve any forest also, it required the approval of the central government. This required the constitution of an advisory committee, which would constitute such a number of people who may be fit to advise the government with regard to grant of approval with regard to any matter connected with conservation of forests. Then the central government had the power to make rules to be notified in the official gazette for carrying out the provisions of this act. Every rule made under the act was to be laid before each house of the parliament, which within 60 days would be comprised of 1 or 2 or 3 sessions before its expiry, and they should have been agreed by both the houses for the rules to take effect. The amendment was made in 1988. An act to provide for conservation of forests was amended. This act was called the Forest Act of 1980. It extends to the whole of India except for the state of Jammu and Kashmir. There was de-reservation of forests or use of forest land for forest purposes, and then there were the defining aspects of the law. The reserved forests or any portion shall cease to be reserved. Land or any portion may be used for non-forest purposes. Forest land or portion may be assigned by way of a lease to any private person or authority, a corporation, agency or organization which are not owned, managed or controlled by the government. Forest land or any portion may be cleared of trees which have grown naturally in the land or portion. And then the non-forest purpose means the breaking up, clearing of any forest land or portion thereof for the cultivation of any of the following activities, which is of tea, coffee, spices, rubber palms, oil bearing plants, horticulture crops or medicinal plants, or any other purpose other than reforestation, but does not include any work which is related to conservation, development, management of forests and wildlife, and establishment of certain other aspects like fire lines, wireless communications, fencing, bridges, culverts, dams, etc. There should be a constitution of an advisory committee, and then the penalty for contravention of the provisions of the act. That it says whoever contravenes or abets the contravention of any provisions, it will be punished with a simple imprisonment for 15 days. Where offence has been committed by authorities or the government departments, then the person who is directly in charge of that activity will be made responsible. So, due diligence should be used to prevent the commission of such offences, and it is proved that offence once committed with consent or connivance will not be forgiven. The power to make rules, the central government shall have the power to make rules under the said amendment, and it would be placed before the houses of the parliament. If they are to be, the Forest Ordinance 1980 was replaced by the amendment made in 1988. 1992 amendment in the Forest Act, some amendments were made which made provisions for allowing some non-forest activities in these forests, which did not include cutting of trees or limiting cutting with the prior approval of the central government. These activities were setting up of transmission lines, seismic surveys, exploration, drilling and hydroelectric projects which were to be undertaken in these lands. It involved large-scale destruction of forests for which prior approval of the central government was necessary. Then the forest conservation rules after that in 2022. These are a set of rules which are established by the Ministry of Environment and Forests and the climate change to ensure that forest conservation is properly managed. It is formulation of an advisory committee and a project screening committee in each state, union territory to advise or recommend matters related to forest conservation. The committees have been given specific timelines for reviewing non-mining projects between 5 to 40 hectares and mining projects within 75 days. For larger projects, the committee gets more time to review, and the rules allow private developers to clear forests without seeking the permission of the forest dwellers, to permit the clearance of a forest without informing their authentic residents. Tribal rights are not violated. State government have been given responsibility of protecting the scheduled tribes' traditional forest lands. Applicants for diverting forest land in hilly or mountainous regions with green cover covering more than 2/3 of its geographical area with forest cover covering more than 1/3 of it can take up compensatory afforestation in other states. Now, the cases which are related to the forest laws in India are the case of T.N. Godavarman Tirumulpul versus Union of India, where the Supreme Court has directed to close down all wood-based industries and embargo was imposed on the exploitation of forest and forest produce. The case of Tarun Bhagat Sangh versus Union of India, where the court, where mining activities in the reserves of Sariska area was prohibited by the court, where it stated it is detrimental to the forest areas and the land within the Sariska reserve. The state of Bihar versus Bansi Ram Modi, who is Honorable Supreme Court has held that the use of forest land for non-forest purposes is impermissible, where the court held that contribution to the development of forest laws to a great extent. Judicial precedents ensured proper compliance of legislation and interpretation of legislation in the best interests of environment and society by the judiciary. The case of Environmental Law WWF versus Union of India, where the court through its judgment took power of the central government and the state governments with respect to forests, sanctuaries, national parks concerning denotification, dereservation. The Godavarman case had made major changes in forest management. The important conditions it laid down in the case was no national park, sanctuary or forest can be de-reserved without the permission from the Supreme Court. The non-forest activities are permitted only if they are approved under the Forest Conservation Act of 1980. New authorities such as Compensatory Afforestation Management, Planning Agency and Central Empowered Committee are to be set up. So, these decisions were for the protection of forests where degradation and various illegal activities in contravention to the forest laws was taking place. Then came the case of Orissa Mining Corporation versus Ministry of Environment and Forests in the year 2013, where mining was being done indiscriminately and the people who were there felt the adverse impacts of the mining activities, went to the court and found justice through the ways of the court. In the case of Sansar Chand versus State of Rajasthan, the depletion of forest cover thereby affecting the wildlife was questioned and answered that it should be done for the protection of environment. Banvasi Seva Ashram was one of the first cases in India where they talked about the protection of the Adivasi rights in these forest areas who were dependent on of their livelihoods on these areas for not only their produce but also their natural habitats. In the case of Union of India versus Kamath Holidays, that they only produced the provisions of Indian Forest Conservation Act of 1980 and stated that where forest lands are diverted for non-forest purposes, compensatory money should be taken up front. The non-forest activity finishes, then it is that time that fund should be used for restoration of those forest areas which have been covered. So, overall our law has made efforts for the protection of forests it depends now on the government and the people's action and a collective action for protecting the forests, not allowing deforestation to take place, and protecting and producing more planting more trees for the purpose of having more forest lands for the survival of mankind and other associated activities. That is the law, it is in relation to the forest in India, and which is improving but is continuously bringing out policies by the government. Thank you.
Hello everybody, welcome back, and here I am to give a preview, very short obviously, in the area of what we mean by operation research and optimizations. So, we know operation research and optimization is used generally where you have some resources and you want to utilize them in the best possible way considering what your main objective is. Now, if we stop here and go back in the past, so the obvious question comes, from where did this technique of operation research and optimization, which is an area of mathematical techniques, come into the existence. So, generally even though the work has started from areas of mathematics, economics, but generally it is considered that operation research and optimizations were very heavily used and it became popular during World War II in trying to schedule different resources, manpower, armaments, considering there were resource constraints, time constraints and space constraints and so on and so forth. Now, for the general public, it should be aware that we consider from the academic point of view, there are different people, very famous people who have worked, but George Danzig is considered the father who really proposed the technique of linear programming as a very nice tool where you can use operation research techniques in order to optimize the resources which are there depending on different constraints which you have. And after that, things have really moved very fast, they have been developing throughout the world, they have been usage, they are different type of societies, so on and so forth. And in course of time we see and we still find exciting areas of application, but theoretically there has been a growth in techniques like robust optimization, stochastic optimization, dynamic programming, parametric programming, nonlinear programming, so on and so forth, and they are used depending on the concept and the areas of application which we see for either finance, for marketing, for scheduling, for engineering field and so on and so forth. Now, application of OR and optimization, if somebody asks, is a very difficult question to answer, because if I start now, it will almost take about 1 hour to give you all the areas of application of optimization and operation research are. But to keep it very brief, considering that you are all ready and eager to take that as a subject, I will just highlight the areas of applications, some of which are in scheduling, in assignment problem, in facility location, like you want to build up a factory, you want to build up some storehouse, so on and so forth. It is used in network flows, like you want to transport some goods, transport manpower from one area to another area. So, how we will try to basically do it in the best possible way. What is best would obviously depend on how you are trying to use optimization as a tool in different areas. It can be used, operation research and optimization can be used in health services, in financial portfolio management, asset liability management, game theory and so on and so forth. Now, in the recent past, even though it is very well known, but still I would like to highlight the point that the computing powers and the techniques of operation research and obviously in statistics has exponentially grown. And with very sophisticated programming being available, like we know that there is MATLAB, there is R, there is SAS, which are different type of optimization tools. We see nowadays that operation research and optimization is also used in health sciences, in gene replication theory, in area of say for example prediction of weather, in the area of say for example prediction of earthquake, how you find out the best possible way to take actions such that it meets your overall demand. Say for example in prediction of earthquakes, you would like to basically build up your houses, build up the dams, build up the overall locations of people staying in different localities in such a way that the minimization of the losses are sustained. Furthermore, after the advent of computing and advent of different techniques, we see many meta heuristic and heuristic techniques are very heavily used in parlance of operation research and optimization by joining them together such that you get the best benefit. So, if the question arises what are the meta heuristic techniques, I would again be very brief, because again there is a huge amount of literature, huge amount of application areas, huge amount of research which are being done in the area of genetic algorithm, taboo search, ant colony optimization, simulated annealing, then in the area of particle swarm optimization, in the area of artificial immune system, and so on and so forth. In the coming years, it is thought, and definitely with some positive viewpoint, that the area of multi-criteria decision making and multi-objective programming, where you use different type of tools and use the different advancement of optimization which has been made in such a way that you can basically optimize two different objective functions which are there in front of you, such that either if considering the area of finance, you can either maximize your return for the portfolio or minimize the risk also, or say for example you want to basically have a layout such that minimization of cost is one factor and the maximization of say for example benefit which accrues to different type of users in this overall layout can be attained at the same time. So, obviously it means that what we are seeing is a huge application of optimization along with different type of computing and heuristic techniques, such that in years to come this area of optimization would become one of the best tools where you accrue and get the benefits in the best possible way. And I am sure that the students or the participants who will take this course will find it an exciting add on to their CVs and to their curriculum vitae, such that they can understand the techniques, how they can be used in the best possible practical sense. Thank you.